The
My lord, item number 1, my lord. I have an application can 1. If Lordship considers for 2-3 minutes, my lord, I will not trouble you more than that.
I have fixed the method for passing interim orders in
Very
respect of the that submissions were made with regard to the writ petition. After that, I will definitely grant you leave to file your affidavit in opposition incorporating
Lord, I
whatever
have
you like.
filed an application. Just see once the prayer what I pray before you. Just once. I'm extremely sorry that they have briefed me much late, but I'm not going to trouble you much. Just consider my application once. I have been added as a respondent in this proceeding. Can 1, my lord. I'm sorry. I'm extremely sorry for troubling you. Kindly, my lord.
Can
1.
Can 1 in WPA 20940.
Can 1 in WPA 20940. That's the second writ petition.
Second writ petition.
Where the issue is the suspension.
can take here.
Because any orders passed in the writ petition may have an impact
On the
relating to the complaint and the subsequent FIR which has been lodged.
when was the FIR lodged?
My lord,
When was the FIR lodged?
FIR was lodged. বলছি আস্তে আস্তে সুযোগ দিচ্ছেন।
12 তারিখ 12
My lord, FIR was lodged on
page 36 12
page 36 if Lordship, my lord, kindly.
So you give the date.
Date 12/9/2025. May I read out the contents of the FIR? And this is
Sir,
I did only after I got
I
the
just tell you
certificate.
before getting into the merit
I
of
was
your
not there, my
application.
lord. I was not there.
Huh?
So,
You should understand one thing,
Lordship,
that the writ petition is session before the honorable court.
Lordship,
One of the learned single judge has released the matter.
I read the
It has
order.
been assigned to me.
I read the order, my lord.
Correct?
Yes.
I have given everybody the opportunity. In fact, when he took the point, I asked the petitioner, implead him. Serve a copy.
Lordship,
11 September 2025, I have concluded the hearing. That's why I asked you, when did you file the FIR?
right, my lord. Then after that,
The allegations are not that it is coming for the first time. The writ petition, second writ petition has been filed prior to 11th September.
yes, absolutely.
After I conclude the hearing, you lodge a FIR. Now you file a can application.
I know, my lord, what is going through your lordship's mind, but kindly see, my lord, prayer once.
This is the fact.
I will
I'm not stating anything.
No,
This
no,
is the fact which has gone down.
Absolutely, my lord. What Lordship has said, my lord, is absolutely correct. But kindly consider prayer once. What I pray, it's absolutely innocuous prayers. Charges were framed against the petitioner, and one of the charge was, my lord, that the principal has made certain allegations which is not at all acceptable to me, and that's why, my lord, my certificate was taken. Subsequently, I got it back, and then on 12th, I lodged a complaint, and pursuant thereto, on the following day, police proceeded and lodged a FIR. And there is provision in the Scheduled Caste Act which says it's a punishable offense. My lord, kindly, my lord, comes to prayer what I pray. Because I was not there, only clarification that I am seeking, my lord, this should not prevent any order to the police authorities in proceeding in respect of the FIR. Because
no, I didn't get you.
Lordship, kindly, my lord, takes up my application.
No. What did you say?
My prayer is, the only prayer is that any order which may or may be passed in the writ petition would not prevent the police authorities to take steps against the petitioner in terms of the FIR which has been lodged. That's all. That's the clarification. That's an independent proceeding. That's an independent proceeding.
I tell you one thing. We have to restrict to the writ petition.
Absolutely.
Had they prayed anything?
No.
What is the preventing the authorities?
No.
If you have lodged the FIR, let them come up with an application.
I tell your lordship.
They have not prayed for anything of that sort.
My lord, just one thing. They have asked for quashing of the suspension. And in the first writ petition, show cause was an issue. In the interregnum, suspension notice was issued. Suspension notice was issued based on certain charges. And one of the charges, if Lordship sees, is the charge that was leveled against me. So if an order is passed, they may take it as a tool that you cannot proceed with the FIR. That's the clarification.
Not touch on that until and unless you serve the copy. And
I have served everybody. I've served everybody, my lord.
Fine. Let them file the opposition to your prayers.
I know I have
the copy.
Everybody has been served. I have come at the very fag end. I will not trouble your lordship.
We will see
We
what
want
is
to file the
related.
opposition. We'll deal with.
But what I reasonably apprehend, my lord, that immediately another writ petition will come staying this FIR because suspension has been stayed. That is the apprehension, I tell your lordship, honestly. Rest I leave it to your lordship. That lordship knows it. That's the apprehension. Whenever you
We cannot stretch our imaginations.
No,
to
I know, I know,
you
I
come
know.
with that.
Surmise and conjecture we cannot, but that's the thing that is possibly that a suspension has been stayed, therefore no effect to charge sheet. You proceeded on the basis of a charge sheet, so complaint FIR all stayed.
It's not that you will not be, you are remediless. If they file the writ petition, you have the opportunity to place your case also.
That, my lord, I
Whether
always
it has-
have. Kindly, my lord, record that I have filed an application and give direction whatever way the court feels, my lord.
Not now. Can one, I tell you, since you have served the copy,
And on record,
so yes,
it's appearing in
they
the
will
list
be
also.
asked to file their. And what about the other can which you have filed? They have filed their opposition?
There are some strange thing happened. I have filed that can.
Huh.
After filing of this can, we got to email the advocate on record. Now, in that email, my lord, it was told that though their problem is not solved yet, but they are not willing to proceed with this can. That is the email. I have the copy. I want to furnish those copies before your lordship.
So right
And
now,
that's why.
Asun,
But
There's
আমি স্যার
Uh,
added respondent
by
রয়েছে,
the
complaint continuous
writ petition, writ petition
order দিলেন উনি
5396 of 2025,
যদি অর্ডার দিয়ে দেয়, যদি প্রিন্সিপাল
the,
তাহলে ওর উপরে
Yeah, তখন he will be independent, right?
the, yes, Mr. Bhattacharya,
No, but I was waiting for the order.
now you have started just. Yes,
Sorry for
come
troubling
up
your
with
lordship.
a can application wherein they say that there are certain allegations again under the SC/ST Act, suppose. So they have filed an FIR to prevent that this order shall not affect that. I tell them that you have served the copy, let them come up with an opposition because we have to restrict to the writ petition.
That's all. Nothing to worry, nothing to worry. Certificate না থাকলে এমনি
Uh,
চলে, আবার কথা হচ্ছে।
Certificate we got
By
it.
the
তাহলে আবার
writ petition number such and such,
ওটা এমনি চলে যাবে।
the petitioner has sought for
না
quashing of the notification, quashing of the so-called notice dated 3rd July 2025 within bracket annexure P7, as well as for quashing of the notification dated 9th June 2025 being number 375-EDN within bracket CS/4C-66/2020 annexure P1. By the second writ petition being number WPA 20940 of 2025, the petitioner seek for setting aside of the impugned order of suspension dated 29th August 2025, annexure P4, and for setting aside of the purported order of appointment of vice principal VD number 624/EDN within bracket CS/DPI-99/350 taken a minute prayer reader numbers dated 25th August 2025. Mr. Vikas Ranjan Bhattacharya, learned senior advocate, along with Mr. Subir Sannal, learned senior advocate, appearing for the petitioner, submitted that the petitioner, this matter is appearing under the heading for all. Submitted that the petitioner joined as principal of the college, namely Rani Birla Girls College, on 29 September 2022, when the said college did not have a governing body, within bracket in short GB, and was run and governed by an administrator officiating from Department of Higher Education, Bikash Bhavan, Salt Lake City. The administrator got transferred and a new administrator was introduced till the notice for formation of GB was passed.
My lord,
Yeah.
may I take your lord?
Yes.
Grateful, my lord.
On 9 June 2025, respondent number 3, Deputy Secretary, Government of West Bengal Higher Education Department, issued a notice to the principal of the college to take necessary steps in the subject as mentioned in the said notification and furnish a report to the said department at the earliest. By the said notification, the appointment of the administrator made earlier on 16th March 2024 was cancelled. From the import of the said notification, it is clear that the principal was supposed to take steps for constitution of the governing body. The issuance of notification does not mean formation of the governing body. Referring to section 3 within bracket 12 of the West Bengal Universities and College, University College within bracket Administration Regulation bracket close Act 2017 within bracket hereinafter referred to as Act of 2017, he submitted that governing body means the governing body of a college duly constituted as per the prescribed procedure laid down by the rules, orders, notification of the state government. Further, Section 5 of the Act of 2017 provides that the governing body shall consist of 3 whole-time regular teachers and 1 non-teaching staff elected amongst them along with nominated members. He informed the court that the election of 3 whole-time regular teacher and 1 non-teaching staff is yet to take place. In such circumstances, the governing body of the said college has not been constituted till date, as required under law. Further, referring to Section 4 of the Act of 2017, he indicates that the president shall be a person interested in education. The notification dated 9th June 2025 does not depict that the president is attached to any educational institution or of the like nature. Thus, the appointment of the president vide such notification on the face of it is infraction of the provisions of Act of 2017. It is settled principles of law that mere nomination of a person for the chair as the president of the governing body and other persons to be the members of GB by the state government does not amount to reconstitution of the governing body. Thus, when the governing body has not been reconstituted, the president nominated has no authority to take decisions. By the present writ petition, the petitioner challenges a so-cause notice dated 3rd July 2025 issued by the nominated president. The issuance of such a so-cause against the petitioner is without jurisdiction. He, in his usual fairness, submitted that ordinarily a writ petition would not lie against a charge sheet or a show cause notice for the simple reason that it does not give rise to any cause of action. Stop. However, a writ lies when the same has been issued by an authority not competent to initiate the proceedings. This issuance of show cause notice adversely affects the rights of the petitioner, and thus by way of a writ petition, such show cause notice has been challenged. In support of his contention, he relied on the decision of Honorable Supreme Court in 2012. Passed in Secretary, Ministry of Defence and others versus Prabhas Chandra Mirdha, reported in 2012, Volume 1 SCC 565, and another decision of this court in Abdul Malik versus State of West Bengal and others, reported in 2012 SCC Online Calcutta 4989. Furthermore, he submitted that the second writ petition is a challenge to the suspension order issued against the petitioner during the pendency of the earlier writ petition. In view of the provisions of the Act of 2017, the subsequent order of suspension is also without jurisdiction, since the governing body has not yet been reconstituted. The general principle applicable to consequential orders is that once the basis of a proceeding is gone, any intermediate action by the authorities in the meantime will fall on the ground. Stop. Such principles applies to judicial, quasi-judicial and administrative orders as well. To buttress his contention, he relied on the decision of Honorable Supreme Court in Badrinath versus Government of Tamil Nadu and others. They reported in 2000, Volume 8, SCC 395. He also indicates that the order of suspension has not been issued in terms of West Bengal College Teachers within brackets Security of Service Act 1975, which empowers a governing body to place a teacher under suspension if there is contravention of, under suspension where there is an inquiry against him under subsection 2 of section 9 is contemplated. In light of his aforesaid submissions, he prayed for stay of the show cause notice dated 3rd July 2025 and all consequential orders passed, including suspension order dated 29th August 2025. On the contrary, Mr. Kishore Dotto, learned Advocate General, appearing on behalf of the state, submitted that Section 5(1) of the Act of 2017 clearly empowers the state to nominate a president of the governing body from outside. Therefore, the nomination of the president made by respondent number 3, vide later dated 9 June 2025, per se cannot be said to be bad in law. And